The Supreme Court's the 19th of December judgment marks a significant shift in how corporate social responsibility, or CSR, is interpreted under Indian company law. By placing environmental protection within the legal meaning of CSR, the court has moved it from being a voluntary act of charity to an enforceable corporate obligation. The ruling builds on the court's long-standing concern over the deaths of the critically endangered Great Indian Bustard due to power transmission infrastructure. Importantly, the court held that corporations, as legal persons, share the constitutional duty under Article 51A(g) to protect the environment and wildlife. Therefore, spending CSR funds on conservation is not philanthropy, but a way of fulfilling a constitutional responsibility. This interpretation strengthens the hands of conservationists seeking corporate financing for damage caused by large infrastructure projects. The court's earlier 2021 order restricted overhead power lines across vast areas and mandated feasibility studies for undergrounding. In 2024, an expert committee was set up to balance species protection with renewable energy expansion, and the latest judgment operationalizes this approach. CSR-linked funding can now potentially support long-term costs such as breeding programs, chick release, and grassland restoration. However, the judgment remains limited. It does not specify which companies must pay, how much, or under what monitoring framework. Enforcement still depends on existing compliance mechanisms. Ultimately, the success of this ruling will depend less on legal doctrine and more on effective implementation by governments, utilities, and corporations, and whether funding leads to real conservation outcomes on the ground.